Well, good morning and a very warm welcome to you all to this session. But before we begin, may I again add to the tributes already paid to Shimon and to his twin achievements of his 75th anniversary and the great founding of this organization, which has done so much to promote, as I know in England and Wales and the rest of the UK and Europe, the position of judges and the necessity of their independence. This morning's session is devoted to a project that is being undertaken by the European Law Institute together with this organization. And it was brought about because of the huge transformation that has occurred in Europe over recent years and the need to try and ensure that modern standards of judicial independence were applied to a very different political structure. You may all ask the question, why do we need another set of standards? I am sure this session will provide the answer. And although I may have more to say as we continue, may I first introduce Professor Frederick Zoll. It's an enormous pleasure to do so, as he really was the inspiration for this joint project when we last met in person in February 2020 in Germany, in Potsdam, where there was the last, I think, in-person conference of the organization. There we decided this was something we should embark on. And it's a wonderful, down to his determination and his energy, have we moved forward. Frederick.
Thank you very much, John. It's really a pleasure to be here and to be here in this session, and also to celebrate the anniversary of Shimon, Professor Shitrit, and it's a great pleasure for me to be here. I'm so sorry that it's not possible to be in Jerusalem this time, but I hope it will be possible in later period. My short speech should concern the question why the European Law Institute started a project together with the Mons Scopus, with the Association of the Judicial Independence and the World Peace, and to work with the standards, Mons Scopus standards on independence of judiciary, somehow to adjust them to the more specific European situation. I was working with the group on Mons Scopus standards already for a long time. It's difficult to calculate, but also several meetings were organized in Krakow and in Osnabrück, at my two places, universities. And of course, the standards, the Mons Scopus standards, have been envisaged for universal usage. And probably the advantage of them was also that it was not prepared only by judges or by one professional group, but having also practitioners on board from different professions, legal professions, and also academics. It is a little bit different. It was a little bit different approach to many other standards. We have a lot of standards, but many of them are just done by judges, for example. And I think it is not always a good approach where the profession itself drafts the standards on independence. It is something which must be probably discussed from the broader perspective. And I think it was one of the great advantages of the Mons Scopus standards that they have provided this broader perspective. But of course, we are in Europe in quite specific situation. And I'm coming from Poland, and Shimon in his opening speech was also mentioning Poland as one of the countries where the independence of judiciary has been challenged. And it has been challenged by political forces, and it launches a crisis which also concerns the European Union. And we have a very very specific development in the European Union, but not only in the European Union, but also in the case law of the European Court of Human Rights. And unfortunately, a big part of these judgments concern my country and develop the standards of the European standards concerning the disciplinary responsibility of judges, the appointment of judges, the right to the court in the situation where in panel are judges which have been not appointed in the proper constitutional way, and when the guarantee of independence is not provided. These are new challenges for the questions how to balance the accountability and the independence. So these two fundamental values of which we have to discuss. And therefore, the European Law Institute decided to work on Mons Scopus principles, looking on them, somehow appreciating this certain perspective, well-balanced perspective between accountability and independence, between a need to look on proper, that the judiciary reflects properly the society, but also that the culture of judicial independence is observed. So this fundamental features of the Mons Scopus standards is a good starting point, because of course, anyway, I'm coming from a country and I'm somehow involved also in this political struggle, and not in this political struggle. I have to say I'm also not only I'm looking on not only from the academic perspective, but also from somehow political democratic perspective, being very critical on what is happening in my country on this political level. But nevertheless, I was also critical before this crisis started 6 years ago in Poland, how the judiciary was constructed. Even in Poland, the situation was quite specific. It was not we didn't have a problem of corruption in the judiciary. Even the government tries to argue that it was the case, but we didn't have such kind of problems. But we had a problems of quality and efficiency. And therefore, the deep reform was needed. But this need for reform has been abused in order to subordinate the judicial power to the word of politics and make it somehow open for political impact. Therefore, it is necessary to reconsider what is exactly the admissible battlefield for politics in relation to judiciary. How this accountability can be indeed implemented without endangering the independence of judges personally, but also about the whole system. We have also to admit, and this is another challenge for the Mons Scopus principles, that as we are talking about judges, the differences among different legal traditions are enormous, and we are very often underestimate them. Talking about the systems resulting from or systems of common law systems and continental systems, we can say, oh, these are judges and these are judges in both situations. But we have a very different construction of judiciary in the system of the career judiciary as in continental system, that you want to be promoted, you want to advance, starting from the lower court as a young young person, young jurist, and then being promoted to the higher courts, which creates another problems, another challenges for the judicial system and for the independence, because when we have to deal also with some kind of internal independence of judges, so how the system beyond the judgments itself tries to enforce certain behaviors and certain judgments, and then we have to think how to provide this way of assessment of judges, evaluating the quality, in the way that it's not only a self-protection system of the group, but again, the independence from the political impact is secured. And the Polish example, I don't want to, this is, and I'm fully aware that it must be, and I have to be careful, because the Polish experience of the country which somehow emerged from the communist dictatorship into democratic system and goes now the way a little bit, or returns to certain kind of fully democratic regimes. It's not a universal experience, but we may see the similarities in different countries. But this particular issues that we had not really not so bad judiciary makes a little bit another challenges to the countries where the issue is that sometimes the judiciary is corrupted and must be done something about it. And of course, these are very two different approaches. And also this Polish experience, it is unique in this sense that after the transition of 1989, it was the experience of communism and the need to make the judiciary extremely independent. And maybe this extreme was going too far in certain aspects on accountability, and accountability suffered on it, and therefore we need to find a kind of balance. And I think, therefore, coming to my end, my time is, I think, it's going to the end. But therefore, the Mons Scopus principles, the standards, are a very good starting point to make now a draft which will be useful in this continental framework of which is dominating in Europe, having in mind all differences which exist further. And this is extremely important, try to how to envisage the standards for countries with quite different legal cultures and quite different democratic experience. And it is of course so that the democratic experience and culture of independence is probably a decisive moment for the functioning of judiciary in different countries. But of course, it must be also warning, because we experience a very dangerous times, also talking about the political development. And it is very easy that this certain established political culture of independence could be abused, and then it's very easy to come to a situation where the independence of judges does not exist. And Poland is one of examples how quickly it may happen. And always another example, because the self-defense of judges is so strong that it was not so easy, and is not easy for political forces to break the individual independence of judges. And this experience also of self-defense of judges is a very interesting experience from the perspective of drafting the principles, also dealing with the question, what is the role of the judge in the society, and what kind of role the judge may play in a society, also in defending the democratic values in the country. Thank you so much for letting me speak about it. Thank you.
Frederick, thank you very much. You dealt with some very important issues to which we shall return during the discussion. And it's now my pleasure to introduce Sophie Turenne, who, apart from the enormous distinction of working with Shimon on his seminal work on the independence of the judiciary in England and Wales, has been an avid student and commentator on broader European developments. It's a great pleasure to introduce her. Sophie.
Good morning. I'd like to express my thanks to the organizers for their invitation. I'd like to express my thanks to the speakers for their stimulating talks on Tuesday and Wednesday. And I'd like to thank Shimon Shetrit in particular. I met Shimon a bit more than 10 years ago, and I continue to learn from him. More than that, his is a unique personality, and I always enjoy our conversations. Moving on to my talk, I'd like to say a few words about the case law, about the European Court of Human Rights and the Court of Justice of the European Union's case law on judicial independence. As we all know, in 2018, in a Portuguese judge's case, the Court of Justice of the European Union turned the principle of judicial independence into a constitutional principle of European law on which the entire EU system of judicial protection is built. This was a groundbreaking judgment. It marks a step further in the integration of judicial system within the European Union. And judicial independence is now an autonomous principle of EU law. One may yet wonder whether the substance of the Court of Justice's case law is likely to add much, if anything, to the case law of the European Court of Human Rights. This is crucial for our work on the Eli Mont Scopus principles as we pull the case law of the two courts together to gain a full picture of the European problems our standards need to address. My first point is that in spite of the careful judicial drafting presenting judicial independence as an autonomous principle of EU law, the Court of Justice will follow closely the case law of the European Court of Human Rights on judicial independence simply because of the mandatory connection between the European Convention of Human Rights and the Charter of Fundamental Rights of the European Union. Under Article 52.3 of the Charter, the level of protection of the right to an independent court or tribunal and the right to an effective remedy under the Charter cannot fall below the level of protection established by Article 6 and Article 13 of the European Convention on the same subject. Moreover, why reinvent the wheel if the Strasbourg approach seems about right? By way of illustration, I'd like to consider the issue of judicial secondment in the case law of the two courts. In some countries, judges may be seconded from one court to another to help dealing with a backlog of cases and to ensure a faster resolution of disputes. In Poland, however, the secondment of judges has been criticized over the years, and in the case of W and others, in May 2021, the Court of Justice of the European Union held that the Polish arrangements on secondment were in breach of the right for individuals to an effective judicial protection under EU law. In W and others, first, the Court of Justice reasoned that secondment to a court in itself is compatible with judicial independence, provided that it comes with safeguard for judicial independence. In support of its position, the court cited the first judgment given on the matter by the European Court of Human Rights in 2011 in Richard against Poland. But also, in WB and others, the Court of Justice was concerned to find that the Minister of Justice in Poland also held the office of the Public General Prosecutor. Secondment to another court, to a specific court, therefore enabled the Minister of Justice to send both his favoured judge and prosecutor to the same proceedings. Further, the executive discretion on secondment meant that judges may have an incentive to rule in favour of the prosecutor or of the Minister of Justice. Finally, the fact that some of the seconded judges also held the position of disciplinary agents for ordinary court judges added a chilling effect to their secondment as judges. The court's reasoning is exemplary. It supplements and it reinforces the principles recognized by the European Court of Human Rights. Whilst on the topic of secondment, I'd like to add that judges can also be temporarily be seconded to the Ministry of Justice itself when they might, for example, assist in drafting legislation. In favour of this option, it has been argued, as in France, that this is a way to export judicial expertise and therefore to raise the profile of the judiciary. It is also a way to expose judges to the state administration's ways of thinking, and in return, it makes the state administration better aware of the constraints under which judges operate on a day-to-day basis. I imagine that both European courts will similarly say that this is not in itself incompatible with judicial independence, but again, much will depend on the safeguards provided and on the role of these persons when they return as judges to the courts. My second point is that the framework of European integration might nonetheless justify greater scrutiny and a wider scope of scrutiny from the European Court of Justice, from the Court of Justice of the European Union. This is because the level of discretion left to member states and the level of scrutiny of the Court of Justice is directly linked to the degree of harmonization provided by EU legislation. For example, in WB and others, the Court also relied for its decision on the European Directive 2016/343 on the presumption of innocence. The need to maintain mutual trust between European countries, within European countries on criminal proceedings is vital. And so the directive gives further bite and justifies greater scrutiny from the Court of Justice. In the case of WB and others, the Court also relied on Article 19(1) of the TEU, the Treaty of the European Union, the right to an effective judicial protection, read in light of Article 2 of the TEU, which refers to the rule of law as a core value of EU law. In terms of judicial independence, Article 19(1) TEU and Article 47 of the Charter, which I mentioned earlier, have exactly the same content. But Article 19(1) of the TEU has a wider and deeper scope of application than Article 47. Combined with Article 2 of the TEU, which, as I said, refers to the rule of law, Article 19(1) enables the Court to address the systemic and transversal changes affecting judiciaries beyond one single and formal rule. These are changes which affect the whole judiciary at any time, such as forcing judges into early retirement, as in the case of the Polish Supreme Court, which came before the Court of Justice with a decision of the Court of Justice in 2019. So the EU framework de facto gives a potentially very wide and deep scope of application of the Court of Justice case law on judicial independence. My third and final point is that the two European courts are at pains to emphasize that member states are not required to adopt any particular constitutional model governing the relationship and interaction between the various branches of the state, provided, as it has been said, that some basic separation of powers, characteristics of the rule of law, is maintained. Whether the two courts in practice do impose a specific understanding of separation of powers, and if so, whether the Court of Justice might be more inclined to take that step than the European Court of Human Rights, is a separate issue that I am happy to consider in questions. My overall point for now is that so far the Court of Justice case law very much amplifies the case law of the European Court of Human Rights on judicial independence. In conclusion, the Portuguese judge's case in principle opens the door to a wider scope of enforcement of judicial independence within the European Union. However, the core understanding of what judicial independence requires, either in a sense of abstract rules or when applied to particular facts, that core understanding appears to be the same in both courts. And so far, the harmony between the two courts in their response to these distinct problems is remarkable. Thank you.
Well, thank you very much indeed, Sophie, for that very broad and careful analysis of the developments in Europe and in the two principal courts. We now turn to David Kosar from Masaryk University, who has enormous distinction in the general area of constitutional rights and the position of the judges. And he's going to talk about the very difficult issue of judicial appointments, bearing in mind the very different approaches that each state takes to judicial independence. David.
Thank you very much, Thomas. Thank you very much to all the organizers for inviting me to this conference. I apologize, I have a slight cold. And also I would like to echo the previous speakers and thank to Simon Chytrid for his enormous work on judicial independence and courts and judges more generally, which we all learn a lot from. Speaking about my topic, judicial appointments and the challenges of drafting early Mount Scopus standards on judicial appointments, I would like to mention 5 key challenges that I think are present over here. As already said by Frederick and Sophie, it is quite clear that drafting early Mount Scopus standards that are sort of tailored to the European standards is peculiar for several reasons. First of all, we have 2 supranational courts involved in this area. As Sophie mentioned, the European Court of Human Rights and increasingly also Court of Justice of the European Union. Therefore, we can see much greater judicialization of judicial politics and also judicialization of judicial appointments than elsewhere, because not only domestic constitutional courts and administrative courts, but also 2 supranational courts are involved, and the new case law in the Republika judgment of the Court of Justice concerning multi-selection of judges, or case law of the Strasbourg Court on in Astrad's own case regarding the Icelandic selection of judges, also shows that it's not only the issue in, let's say, Central and Eastern Europe, but it's a big issue also in consolidated democracies. So bearing these specifics in mind, I think the first challenge is the diversity of the models and I would say judicial selection rather than judicial appointment, because appointments are just one potential mode of judicial selection. Even in Europe, even if you look only at Europe, we can see that still quite a few judges are elected. I mean, judges of constitutional courts are elected in some countries, like in Poland, like in Germany. But also judges can be elected by the people, like judicial departure in Italy or commercial judges in France. And also even if judges consider only judges being appointed, we can see a plethora of different bodies that can be involved in that. It's no longer an era where the executive was the key player in judicial selection. Nowadays, we increasingly see selection commissions, judicial appointments boards, and judicial councils. And sometimes we can see also very complex hybrid models when some of those selection bodies are combined with the action of the Ministry of Justice or the president of the country or monarch or any other actor. So coming up with a standard that would provide guidance to all of those models is a big challenge in itself. And I think it's pretty much clear that we need to come up with substantive standards that are not necessarily tied to a particular model. And probably we also need to distinguish between selection of lower court judges and the selection of apex court judges and constitutional court justices. So the second challenge, and this is something we learned rather recently, is that basically any of those models can be abused. We were sort of used to challenge the misuse and abuse of selection of judges by the executive. But the recent experience from Poland, in particular, Friedrich mentioned it earlier on, but also elsewhere, shows that even judicial councils can be captured, and even those bodies can be misused and abused, and that may negatively affect selection of judges. And this applies, of course, to specific selection commissions and hybrid system as well. And therefore, we again need to find ways how to minimize the risk of the capture or polarization of selection of judges, irrespective of a given model. The third challenge, I believe, is that it's not only about the formal rules and formal institutions, and this is one of the trickiest issues, because if we look only at the eligibility criteria for becoming a judge, that's just one part of the puzzle. We also need to know what factors influence the pool of candidates that are actually actively considered or apply for a given position, and informal constraints behind that. Because if we know, for instance, that in Spain you need to study for several years to pass the judicial exam, it's quite clear that only, let's say, persons from a certain social class can afford this luxury to become a judge. The same applies to the big issue of diversity, which is a big diversity of the judiciary, which is, for instance, big in the United Kingdom, but I haven't seen a similar discussion in many countries in the continental Europe. This is basically still an issue to be discovered and to promote and applications for the position of judges by members of various minority groups. And of course, we think of it as a sort of a funnel. We have the eligibility criteria, who applies, then we also have the rules of shortlisting, and then only comes the final selection of judges. And that's quite clear that at each of these stages there might be informal factors and informal institutions that might come into play. For instance, if Minister of Justice informally talks to the Chief Justice about the filling of the vacancy at the Supreme Court or something like that, this is important to know, and this is important to keep into account. The fourth challenge, I believe, is the issue of transparency, competitiveness, and the fairness of the process as such. We have seen several judgments recently of supranational courts in Europe showing that certain amount of discretion of political actors in selecting judges is acceptable, but this discretion is not unlimited. And if there are rules set in a given jurisdiction, they must be followed. Of course, there's a big issue to what extent the transparent selection of judges helps the cause, especially when we consider applications for an office of a judge by members of other legal professions. Because of course, if you are working as a partner in a big law firm, you don't want your bosses to know that you are gonna leave in a short term and so forth. But it's quite clear that the rules, at least how this is done, must be transparent and must lead to competitive selection. And finally, the fifth challenge I would like to mention is that if judicial selection is supposed to be successful, it must find support not only among the elites and legal professionals, but also among the ordinary people, and it must be organized in a way that increases public confidence in the judiciary. And one way potentially, and that's a big challenge for us right now, how to do that is to involve the lay persons in selection of judges. We have seen it, for instance, in the UK, both in selection of Supreme Court judges and regarding the membership of judicial appointments commissions in England and Wales, in Scotland, and in Northern Ireland, where laypersons are involved. And this is potentially one way how to bring in people outside of the legal profession, outside of the usual suspects like the Ministry of Justice and members of the judiciary, and potentially also how to, let's say, prevent the capture of those bodies that are involved in selecting judges. But here I would like to stop, and thank you very much for your attention, and I'm looking forward to your questions and comments.
Thank you much indeed for that very interesting discussion of this difficult problem of judicial appointments. And we now turn to Professor Marko Novak, who has been president of the Slovenia Council for the Judiciary and a member of the European Network of the Councils of the Judiciary. Councils of the Judiciary were thought to be a very important buttress for judicial independence, but they didn't work, as has been pointed out already, in the case of Poland. I therefore very much look forward to Marko's discussion on challenges to judicial independence.
Dear colleagues, my name is Marko Novak. I am a professor of jurisprudence and constitutional law in Slovenia at the European Faculty of Law of the New University, and a former president of the Judicial Council of the Republic Slovenia. That is our council for the judiciary. And it is, particularly the second mentioned capacity that enabled me to begin understand the problem of judicial structural independence in Slovenia, in particularly concerning judicial appointments. And this will be the area that I'll focus mostly in my presentation, because we will be able to see that there are certain challenges to that that need to be addressed properly in the future. Yeah, by judicial structural independence, I basically mean legal structures or formal laws in a particular country, such as the constitution and relevant statutes that enable the judiciary and and judges, and the judges to make decisions, based solely on the professional criteria. At least, in any case, free from any political influence. And what is important is to design within the separation of powers system and applying checks and balances a proper balance between the branches of government in order to safeguard judicial independence. If there is too much pressure from the political branches on the judicial one, so judicial independence can be at peril. And we'll see, this problem in the structure of Slovene constitution, especially when it comes to judicial appointment, because even they are based on professional criteria. Finally, it is the politicians who decide who is to become a judge in Slovenia. Yeah, the basic problems is the constitution itself, particularly Article 130 dealing with the election of judges. It says judges are elected by the National Assembly on the proposal of the Judicial Council. That is, even though the new constitution was adopted in 1991, this was a remnant from the socialist past, in which what prevailed was not the separation of powers, but the unity of powers, in which the National Assembly was the central body of the central government authority. It goes back to the Rousseau's idea of democracy. Yeah, that particularly was in force in ex-socialist countries, and in that system, judges were elected for a renewable 8-year term, and so in practice, the politicians didn't, get involved into seriously reviewing those proposals, but occasionally, from time to time, they refused a certain candidacy. So in those cases, not professional but political criteria came to the floor. The problem with this political criteria is that when making their decisions, politicians don't provide any reasons. They just press their buttons, and these kind of decisions cannot be evaluated at all, and could be fully arbitrarily. Yeah, and what are basically, and so the framers, when enacting, when adopting the new constitution, were not obviously aware of that problem, or were perhaps afraid of coming with something new, with a system that would be, enforced in other, maybe older democracies. And now Slovenia, I think, is one of the last countries in Europe that still, provides for the election of judges by the parliament. Yeah, and so what are practical implications of that constitutional provision? The optimistic scenario is that usually, or most often, MPs are just a rubber stamp for the Judicial Council's proposals, and they don't really go into into reviewing, the specific proposals and all these things. But from time to time, a pessimistic scenario takes place. And even though the politicians are aware that maybe that power that they have is not appropriate for them, if they have it, and these are the words of one of the politicians that I very much remember, if they have, they powered, they will not just pretend to be the British Queen and just approve the proposals in a more protocol manner. And from time to time, they vote against, and they refuse the proposals made by the Judicial Council, which are really based on professional criteria. I personally witnessed several of these, of these problematic refusals by the parliament, which was really based on some populist arguments, not really on some professional arguments. In one case, the politicians got simply offended when they thought that the Judicial Council didn't properly communicate with them. So their arguments were really irrational, and so it is really. You cannot base, such reactions on any proper, rational or reasonable arguments. But this is not when it comes to the problem or the challenge to the structure independence in Slovenia. This provision is not the only problematic. There is another one referring to the appointment of Supreme Court judges. If a judge wants to run for a Supreme Court judge, they need to go again to the National Assembly, because it is the National Assembly, the Parliament, which votes on the candidates for Supreme Court judges. And so the situation is the same, as with respect to candidates for becoming judges, for the first time. And so this provision is not in our constitution, it is in the Judicial Service Act, and it was criticized even by the Greco, this Council of Europe organization fighting corruption, and they urge Slovenia, in one of their reports, they urge Slovenia to change the statutory provision, but nothing has occurred so far, because the problem is, the risk is for some kind of political involvement, which does not need to be obvious or explicit, but when just pressing their buttons, what politicians can have in their mind could be some political dislikes concerning a certain candidate. And so you'll see there is even one more problem. In order for a candidate who wants to become president of the Supreme Court, there is again the National Assembly who decides on that proposal. Even though this kind of for the top judge, for the higher judge in our country, to appear before the parliamentarians. Maybe this is not so problematic, but the problem is that if one wants to become president, of the Supreme Court, they need to appear at least 3 times in the National Assembly, because for the first time, when they, in order to get their life tenure, for the second time to become a Supreme Court judge, and then finally for the first time to become president of the Supreme Court. I don't see, this democratic element as too problematic, but if it is, if it is emphasized so many times, this could be, I would say, intolerable. Even though, at least in theory, in Slovenia, practically all lawyers, even a vast majority of politicians, agree that we would need to change both the mentioned provisions, the one in the Constitution and the one regarding the election of Supreme Court judges. Nothing has occurred in practice so far. So the proposal, the amendment, would go in the direction of the combination of the nomination by the Judicial Council and the President of the Republic. So the Judicial Council would provide some professional evaluation, professional assessment of a candidate, and President of the Republic would approve, that kind of a proposal in a more formal protocol way. And so I think even in this case, I think the democratic element of appointment will be safeguarded, because in our Judicial Council, 5 of 11 members of the Judicial Councils, who all need to be lawyers, are elected by the National Assembly. So, and 6 are from judges themselves. So, these 5-member persons, these 5, so to say, lay members on the Judicial Councils, they provide this necessary democratic element. And what is also really well, I would say, included in our system is that for all major decisions, a 2/3 majority needs to be ensured, so that no group of either lay members or judges member can outvote the other group. And in my experience, it never happened that particular members would group themselves in according to their appointment. So, but as I said, the professionally, academically, there is almost a unanimous opinion that we would need, a change in this direction. But when it comes to real politics and practical politics, nothing really occurs.
I think
thank you for our attention, and I wish you to enjoy the rest of the conference. Thank you and goodbye.
Thank you very much indeed for that view of the particular problems in Slovenia, which illustrates the problem in Europe. It's not necessary for me to say anything by way of introduction to Szymon, but he's going to talk about the issue of universality and particularity in drafting standards of judicial independence. Szymon.
I wanted to show you from our website the Mount Scopus standards to give it a general look, but we will skip it. My my presentation. So this is the text of the Mount Scopus standards that we developed beginning in 1981 in the conference here in Mount Scopus, and then approved in New Delhi in 1982, and then further studied in Montreal Declaration in 83, and then adopted in 2008, and then revised, and the last revision was in London, and therefore this text that is on the website is the consolidated text of 2018. And so this is the one item I wanted to show you. And over the time, we, in fact, conducted quite a few conferences, show you the various conferences here. As you see, the last one, as Lord Thomas has mentioned, was in Potsdam, right here. And today is the conference number 18 that we are holding in Jerusalem. So, what is the purpose? What is the purpose of the ALI Mount Scopus project? The purpose is to adopt the Mount Scopus standards to the realities in Europe, and this is one of the projects of DLI. It is the initiative of Professor Frederick Zoll, who is participating today with us from Jagiellonian University, with the encouragement and support of Lord Thomas, who is the former Lord Chief Justice of England and Wales, and is the chairman of this session, and the first vice president of ELI. This initiative, as Lord Thomas mentioned, we discussed in Potsdam in 2020, and since then we met so many times. The reporters are Professor Sophie Touraine, whom you heard today, Professor Zoll, and Professor Wortham, and we are very, very grateful for the assistance that we get from the advisors, who are Professor Arens, Professor Korens, who is with us today, Professor Novak, also with us today, Professor Cavallini, Professor Trunk, Professor Ferrari, Professor Storme, who was supposed to take part, but we wish him good health, Professor Rivera, Professor Fleck, and Professor Reschberger. We have been meeting regularly on Zoom to discuss the text and the commentary of the standards, and the target date is April 23 for the final publication, but we will be having some target dates in May 22 and in July 22 for the completion and the work on this very important project. The task of our group is challenging, as it has to take into account not only judicial independence, but also other fundamental values of the justice system. And I would mention a number of fundamental values which are recognized as fundamental principles necessary for the justice system. One is accountability of the judiciary, efficiency of the judicial process, accessibility of the courts or access to justice, and public confidence in the courts. We have to take all this into account as additional values to be considered beyond the issue of judicial independence, which is central to our interest and our study. Another central challenge, which is the specific talk of the specific topic of my talk, is of the reporters and of the advisors, is to draft the revised ELI Mount Scopus standards that will reflect the values of European Universal Desired Standards, but at the same time take into account the particular circumstances of the domestic jurisdictions and the different legal culture and traditions in the various jurisdictions. We saw today, for example, the situation in Slovenia that provide for election by parliament. On the other hand, there are other systems that give almost exclusive power to the judiciary for appointments, at least at the lower level of the judiciary. And so we have a variety and diversity of systems, and the question is, how do we balance between the universal standards and the particular circumstances in the various jurisdictions? In examining the issues of judicial independence in matters of the justice system and matters of judicial appointment, an important question arises. The question relates to the proper balance between the universal standards and as I said, the particular circumstances. So we have two approaches. One is universality approach, and one is the particularity approach. According to the universal theory, universality, an independent judiciary is necessarily a shared value of all legal systems and culture, essential for the rule of law. Universality calls for defining a universal method of judicial independence, reflected in legal rules and other formal institutional arrangements, including in judicial process, judicial appointment, controlling the judiciary, rules in terms of appointment, review of continuation or retention of judges, recall of judges, renewal of the term, as we just saw in Slovenia. All these issues have to be considered according to certain universal rules. For example, one very clear rule would be that judges' terms cannot be changed during the term of office. This is a universal rule, and I think it is to be accepted without qualification. But there are the particularity circumstances, which would be, if we talk about the particularity principle, is that we have to take take account of the circumstances in the jurisdictions and recognize that in some countries it is justified to exempt certain practices from the universal standard. This is what we call the approach of particularity. As an illustration, the international standards first adopted the New Delhi Code of Minimum Standards of Judicial Independence, recognized particularity. We face the issue, how do we reconcile between the general principle of separation between the judiciary and the executive. But the Lord Chancellor at the time, where we talk about 1981, 1982, and until 2005, he had three functions: judicial, legislative, and executive. He was a member of cabinet, he was a speaker of the House of Lords, the upper house of parliament, and he was the head of the judiciary. But we wrote that there has to be separation. And so we added a proviso, we added an exception that this rule will not apply in long-established democracy. We refer to, we had in mind the situation in England about the unity of functions in the Lord Chancellor. At the same time, we had this unity in the Judicial Committee of the House of Lords, that it was part of Parliament, and it was the final appeal court in England. But until 2005, these two situations existed until 2005, unity of function, judicial and legislative with the House of Lords, and judicial and executive and legislative in the Lord Chancellor. Similar situation exists in the Conseil Constitutionnel until today in France, where the membership is totally political. So the issue of particularity arises. How do we decide when to accept as legitimate particular circumstances, and how to not to accept it and invalidate it in the circumstances? So I think the general rule should be, and I drafted just short statement, the task of creating international standards requires taking into account not only judicial independence, but also other fundamental values. A central challenge of drafting international standards of judicial independence is to formulate standards which will reflect the values of universal desired standards. At the same time, the standards must take into account the particular circumstances of the domestic jurisdiction and the different legal cultures and traditions in the various countries. It is proposed that in order to properly analyze compliance with judicial independence in matters of judicial process and judicial terms of office, that we must consider the two approaches, universality and particularity. How do we discern from what is legitimate and from what is not legitimate? I think the right way is that measures taken by countries should be examined in the following test. The test should be whether the aims of the measures, whether legislative or executive, could pass the test of predominantly valid aims of those measures. If the test of predominant aim is failing, that means we should invalidate the measures and not accept the particularity exception. So this would be, in my opinion, the test that trying to establish whether the predominant aim was valid or not. So when you have a situation, whether in old democracies or in new democracies, it would be, of course, to the advantage of all the democracies that their institutions, even if they are not exactly according to universal standards, like the Conseil Constitutionnel in France, or earlier than 2005, the Lord Chancellor or the Judicial Committee of the House of Lords, then the fact that it has existed for many, many centuries, this would give a benefit to older democracies, but I think even older democracies cannot be immune to deciding that certain standards or certain practices are not to be accepted. So I think that the balancing between particularity and universality has to be done in a very careful way, and to, in fact, adopt the test of predominant valid aim. If it is predominant valid aim, whether it is new democracy or older democracies, whether it is new practice or older long-established practice, both have to stand the test of the desired universal standards, but with the examination of the predominant valid standards. Thank you.
Well, thank you very, very much indeed, Shimon, for that very important attempt to balance these two difficult issues. And it's, I think, particularly important within Europe because of the great difference between the older democracies and the more recent democracies, but both may be suffering from the same challenge. We now have a little time, about a quarter of an hour or so, to raise some issues. I first was going to ask if there were any questions that people have got. They should be in the chat, but I don't see any. But could I ask a question while people are thinking? And that is this. Frederick Zoll raised the important question of who should draft the standards. Should judges draft them, or should it be a much broader democratic attempt? And I was going to ask Shimon if he could start this assumption. How important is it that this is looked on by everyone involved in the political process, and not merely judges who have been responsible for the drafting of many of the common law standards?
Lord Thomas, I think your question is well put. I think that the effort of formulating standards must be shared by all stakeholders. I think it would be a mistake to vest this function in the hands of one authority, which is the judiciary, but rather have it in a shared effort, the academia, the judiciary, and representatives of other branches of government, sounding out, because I think that achieving what we need to achieve, particularly in view of the fact that we have to take into account the other fundamental values: accountability, public confidence in the court, access to court, efficiency, fair procedure or due process. All these have to be taken into account, and I think the judiciary would be better off not to be the single organization or the single branch that will assume the responsibility of drafting the standards.
Well, thank you very, very much indeed. I'm having a slight problem with my internet connection at the moment, and I hope you can hear me. But I was going to ask whether either David Kosar or Marko Novak had any comments on what Professor Shetreat has just said. Yes, David.
Thank you so much, Thomas. I completely agree with Shimon. I think that all the stakeholders should be involved. And I also believe that these stakeholders, as I said earlier on, should go beyond legal professionals. So by laypersons, I do not necessarily mean lawyers, either advocates, barristers, or solicitors, or or those working in the in private sector. But by lay persons, I also mean non-lawyers completely. So I believe on many issues we can exploit the help of human resources specialists in terms of budgeting. Of course, we can exploit the knowledge of economists and others special professions, and also members of the civil society are crucial to be taken into account. So the process should be inclusive, and I believe, as I said earlier, and it can be more resistant to capture, because for anyone it is far more difficult to control so many centers of power and all the stakeholders. So if we want to have long-term, durable, good solutions, we need to have an inclusive process.
Thank you very much. Marko Novak, did you want to add anything? No. Well, can I go to and raise another issue for discussion, seeing nothing in the chat as yet? And that is the question of the roles of councils for the judiciary. And there are two questions, I think, that arise which are interesting. The first is, why did the existence of a council in Poland not offer greater protection? And secondly, the councils of the judiciary of quite a number of countries in Europe also have on their structure prosecutors. And so how do prosecutors fit into this, particularly as in some states, prosecutors and judges do change roles from time to time within the same employment structure? David, do you have any comments on this particular subject, as you're on the spotlighted at the moment?
Yes, sure. Thank you so much. I just do not want to dominate the discussion. So I have my own views on this. I think when we look at Poland, this development, I guess, could have been predicted, because I mean the capture of the Judicial Council we could see already in Slovakia much earlier, but it was not, that much medialized, and it was not that relevant because it was not a direct challenge of the supremacy of the EU law. But it shows basically that in a country where the political and judicial culture is not established, it is very tricky to introduce a strong judicial council. To me, it's a sort of, especially a strong judicial council with a majority of judges. To me, it's a sort of tool of what I would refer as offensive constitutionalism. If you have, if the sun is shining, it can achieve a lot of positive stuff, but during the dark times, it can also do a lot of bad stuff. So we need to be very, very careful when we design judicial councils, how to frame them, its membership, its composition, its powers, and how to frame the safeguards. And again, we should not treat it as a panacea. So that would be, I mean, for a long discussion. Frederick, I think, is gone. Why the Judicial Council in Poland was captured, and why there was no protection of the already captured Polish Constitutional Tribunal. But we can see that if we centralize all the powers within one body, it's easier to capture the whole system, because once you control this one and only body, you control the entire judiciary. So maybe having separate judicial appointments, commissions, and some powers vested with the court presidents and other bodies like court service might be more resistant to capture. That's regarding the first question. Regarding the second question and membership of prosecutors on judicial councils, it depends on judicial culture, because when we look at France, Italy, and also elsewhere in Southern Europe, it's quite common that magistrates cover, both prosecutors and judges, and they are sort of, given a very similar protection and are governed by very similar standards. In contrast, for instance, to former communist countries where prosecutors and general prosecutor in particular are viewed with suspicion given our peculiar historical development and abuses of the Soviet-style procuratura. So in those countries, I think inclusion of prosecutors on judicial councils would be viewed quite problematically. But there are ways how to play with that. For instance, making sure that the judicial council in those countries where both prosecutors and judges sit on, the judicial council may split in smaller sections that decide on particular issues, and in that way, judicial independence and public confidence in the judiciary, as well as judicial accountability, can be safeguarded, basically by preventing prosecutors to decide on certain sensitive issues concerning judges in the narrower sense. And again, as I said, if you frame the Judicial Council as a sort of fourth branch institution in terms of recent Mark Dashnes and Tarun Khaitan's work, actors from other pools, such as human resource specialists, civil society members, and so forth, can also provide sort of barrier against the improper rule and improper influence of prosecutors. But again, we need to look at the given political culture, given historical development, and also informal institutions in each country. So I would not rule prosecutors entirely from the membership of judicial councils, especially in those countries where it makes sense and where it is deeply embedded. And I would say where it did not cause any major problems, like, for instance, in France or Italy.
Well, thank you very much indeed. And I see from the note in the chat that I think it's Professor Ferrari is returning to discuss this very interesting subject, particularly for those who come from common law traditions, who see prosecutors in a very different role. But I was going to ask in the remaining minute or so whether Szymon had any comment on the points that have been made, particularly in relation to Poland.
Let's take the Slovenia situation of election by the National Assembly. In some other countries, it does exist, but only for the top courts. For example, the Bundesverfassungsgericht, the Federal Constitutional Court of Germany, is elected. The members are elected by the Bundestag, but it is accepted as legitimate because they wanted to distinguish between lower courts that are engaged in either criminal, civil, administrative, tax, or social matters, and to distinguish it from major decisions about constitutionality of legislation, and therefore they did not use the older system of appointment of judges, which existed for the other courts, the 5 systems of the courts in Germany. So I would say that nobody could say that it's not legitimate in Germany to make that distinction. On the other hand, to have the whole system of the judiciary to be elected in parliament is, I think, a mistake, and I share the comments that were made about it today. So I think every situation has to be examined in detail, exactly as I said about particularity, that you have to go deeper into the system and to check what was the reason for adopting a certain structural model or method of appointment, or all these situations of the higher judiciary councils, unique for Europe, existed, of course, in the communist period, but also has existed for the democratic other countries, the older democracies. But we have what we call lustration situation. For example, in Ukraine, and they have a commission to classify the judges and then decide who stays on after the change of the rule and who doesn't stay on. Now, it's very interesting to say that, in California, for example, they have a system of retention. After the first 12 years, the judge has to be retained. He does not run against anyone, distinguished from the beginning that he runs against others and is elected. So there is a retention system, but it's different because here it is retention generally, and in Ukraine, the Lustration Commission was reviewing it according to some kind of ideological review, and that's why every system has to be judged on the details of the situation. On the other hand, in India, we have exclusive judicial control of the appointment of the Supreme Court judges in India. And this is something that was approved and approved by the Supreme Court of India. And when the parliament decided to introduce a constitutional amendment to change it, the Supreme Court of India declared it unconstitutional. So we have quite a wide spectrum of models, whether it is judicial appointments, or whether it is control on the judicial process and control on the courts, on courts administration. That's why this issue, difficult issue of balancing, is challenging for us. And in order, on the one hand, to have some universal standards, but on the other, to take recognition of the particular circumstances in so many domestic jurisdictions.
Well, Shimon, thank you very, very much for that answer. There are now 1 or 2 questions that have arisen, but as I see it's time for the coffee break. Alexander Trump has raised a very interesting question as to what is the consequence of a poor appointment or flawed appointment process. But no doubt, as the next session is dealing with views on the role of the judiciary, that is one of the subjects that will come up. I was going to ask about judicial activism and climate change, which is now a very, very big issue, both in France, Germany, and the Netherlands, and whether that is going to produce another set of problems in relation to the independence of the judiciary. But this has been a fascinating session. May I express on your behalf the thanks to all of the speakers for their excellent presentation, and to thank Shimon for the enormous amount of work he's doing to try and balance out the need within the whole of the world, but as I'm concerned, mainly with Europe, in getting standards that will work and provide a better protection in the future for the independence of the judiciary, provided, of course, as Shimon has reminded us, judges remain accountable, they remain efficient, a big problem in many countries, that justice is accessible, and somehow they maintain public confidence, something that is steadily being eroded in the United States. Thank you all very much indeed. It's time for coffee, and the next session will start, I hope, on time. But thank you all very much indeed from London.